welcome to the Personal Injury Law Show. This show talks about everything current in the law of personal injuries and obviously of importance to you, the viewer. My name's Tony Carbone. I'm a lawyer of 30 years experience. With me tonight I've got Nunzio Tartaglia, partner in the law firm in insurance law. Good evening, Nunz.
Evening, Tony. Viewers, welcome.
And Sarah Snowden, a senior associate in a law firm in superannuation. Good evening, Sarah.
Good evening, Tony. Good evening, viewers.
Now, viewers, tonight we're going to do an update on superannuation law, insurance law and TPD law. So please stay tuned for that because it's very important in this day and age.
Before we kick off though, Tony, what's in the news?
Well, there's been a lot of stories. The one that I want to kick off with is employees with work-related cancer are missing out on compo. It appears that only about 10% of people with cancer at work actually get compensation on it.
Yeah, look, looking at the stats, I didn't realise it was so low, Tony, and I think that the major cause is, from what the article's saying, is that it's hard to prove the cause of the cancer because obviously it can come from many different sources and means. So, and that's really, I think, where the underwhelming stats come from.
It's sad that, Sarah, that because we don't have enough knowledge about cancers, that people that get injured at work or pick up these cancers at work aren't going to get compensated, don't you think?
I think so, Tony, definitely. And looking at the statistics, I mean, it says 395 claims for cancers are made each year. Now, given the significant number of injuries and other claims that are made through work cover, it's a very, very small number.
But how do you prove that, Tony? If, they're saying that some people get exposed to the sun and that could be a work-related injury. Trying to prove that would be...
Well, in this day and age, because there's been cases in Queensland and also New South Wales, the exposure to the sun and melanomas has become a lot easier.
Okay.
But, things like asbestos have become easier because Slater and Gordon ran those cases 30 years ago now, nearly 30 years ago. But other things are becoming pretty hard, and also people that have been injured, say firefighters. You almost need presumptive legislation to take away all the difficulties. But it's an interesting topic and we should really do it.
I think with time the stats hopefully should go up, but time will tell.
This is an interesting allegation. I'm on the Bully Zero board, Nunz.
I do, Tony.
And there's been this allegation against one of Dan Andrews' ministers of bullying one of his staffers. What's your take on this?
Well, his name's Adam, I think it's Semniak. Probably the best way to say it. But yeah, he's been accused of bullying, and look, he's stood down or voluntarily while an investigation's pending, which I think that's just a bit of a political front. But interesting to see what the outcome of the investigation is, because if they don't get the findings they want, that could be trouble for the government.
It could be a problem. And Sarah, in this day and age, some of the allegations levelled at this particular minister are verbal attacks, physical confrontations and manhandling. I mean, in what, today, manhandling?
Yeah, I think the reported complaints are quite serious, and I think in this day and age, everyone's got a right to feel safe at work, and more importantly, employers have got a duty to make sure that employees are safe at work. So it'd be interesting to see what the outcome of this is.
Look, there's a presumption of innocence, so we can't jump the gun. There's serious allegations, so we'll have to stay tuned to see what evolves out.
But just quickly on that, Tony, if the accuser is saying that she's been bullied, then arguably she can put a work cover claim.
Oh, of course. And she probably is on work cover for all we know. But I'm also part of the Bully Zero board, so if anyone out there feels that they're being bullied, go onto the website and get some ideas, and if you still get stuck, give us a ring. Unsafe cars bagged. Over 500,000 ageing Aussie vehicles part of shrapnel airbags program.
This is massive, Tony. You said Takata, who manufactures basically 20% of most airbags in the world, have basically conceded in open court in the US that there's some defects with their airbags, where I think when there's an accident, shrapnel goes everywhere and can kill people. And in light of this, there's massive recalls not only in Australia but worldwide, mainly in the US as well. And this could be huge.
That's right, and it's already resulted in several deaths overseas, affecting 53 million cars. The main concern is how quickly they're going to be able to replace the parts in those cars, and how in the meantime they're going to prevent any further deaths occurring.
Tell you what, the cost is going to be absolutely horrendous when you think about it.
And they're saying that some of these airbags are dating back to 2003, so trying to even identify all those cars and recall those cars, it's a big job.
Oh yeah.
Big job.
Look, this is going to be interesting as it evolves. We'll come back to it, I reckon.
Yeah, massive.
The RSPCA has been ordered to pay $1.4 million after they shot 131 cattle. Sarah, that's amazing.
It is, Tony. In this instance, it's been argued by the owners of those cattle that the RSPCA acted a little bit hastily in destroying the cattle after there was complaints of starvation, and by way of that, they've then brought a claim with respect to the loss of income from the cattle that's been destroyed.
What do you think, Nunz? I mean, they're supposed to be protecting these
Yeah,
animals, not destroying them.
when I read it, I thought maybe it was like a work cover case at the RSPCA or something to that effect. But no, that's a massive award, and 1.25 for potential profit loss. And Judge Bowman, who obviously we know well-known judge in the county court, was found for the plaintiffs in this regard. And look, shooting 131 without even consultation with the owners, it staggers me, to be honest with you.
Well, you'd think they would have got, I don't know, vets to have a look at the cows.
It's definitely strange that they haven't actually sought any further advice before they've actually gone. They've acted on one complaint that's been made, and given the amount involved, it's really
I'm actually surprised.
concerning.
Well, Judge Bowman's retiring this month, so I want to wish him well. He's had a great period of time on the bench, and also his career in the law's been absolutely sublime. Good luck, Judge. Stress takes a toll on paramedics. Sarah, paramedics, they're very important. They come to someone's aid in diabolical circumstances. What's been going on?
Look, paramedics have an absolute integral role in everyday living with respect to accidents and people needing them for assistance to and from hospital. And in this article, it's indicated that there's more than 300 reports each year of ambulance officers being attacked, verbally attacked, physically assaulted in their day-to-day living and doing their jobs. And 50% of them are actually saying that they don't enjoy the position that they have at the moment because of the circumstances they find themselves in.
Nunz, if someone's concerned about whether they're going to be attacked or along those lines, it's going to make it hard for them to actually treat you properly when they get to the scene.
That's right, and that's, I think, where the double-edged sword is in that one, because obviously the importance of them is obviously paramount, but at the same time you've got to protect your ambulance officers. So we do have a guest from Ambulance Australia coming on in the next couple of weeks,
so be very interesting.
I think we can really probe more into this issue because, we've spoken about it before. I think it's not going to be an issue that's going to go away. And hearing the ambulance officers are suffering from PTSD and the like, we don't want that because they do such a integral job for the community.
Roof bats. This is a Kevin Rudd special, this one. This is where there was a lot of fires and people falling out of roofs and getting injured on the job because of a lack of training. Sarah, what do you say about this? It's just bizarre, isn't it?
Look, it's just a perfect example of, not providing appropriate training before you get someone to go in and do a particular job. So it's in this case, it's been quite a hasty proposition that's been put forward by the government, which ultimately has resulted in quite a few deaths.
And Nunz, not only have they paid a fortune in compensation, but the actual cost of our Australian community from the Kevin Rudd failure, it's just bizarre.
Yeah,
isn't
it hasn't been his finest moment and one I think he just wants to forget about, but unfortunately can't when it's in the news.
Viewers, we've got to go to a sponsors break. Stay tuned. After the break, we're going to be talking about superannuation and what you need to do to protect your position. Welcome back to the show. We're going to give you this update on superannuation and insurance law. Now, insurance law is when you take out a policy in case you get injured at work or if you get injured outside of work and you want to cover your loss of income. Now, some of the pitfalls, Nunz, are people get injured. These policies talk about retraining. They don't do retraining. They talk about alternative, what you're suited by age, education, experience. They don't cover those issues either. So, anything else you'd like to add before we get on to the case?
Yeah, look, I think this issue of superannuation is one that, we touch on regularly, but I think we've got to really focus down on it because it's such an integral part, I think, to protection for workers and not even non-workers. Look, we've got an example. A work colleague the other day had a nasty accident. Didn't happen at work, but luckily he's insured. He's got income protection, he's got TPD, he's got everything. So in worst case scenario, he's covered. And, these are examples as to why, because sometimes this is the only livelihood you got, Tony, and, you've got to protect yourself.
And Sarah, in a lot of instances, we find that the only compensation or benefits that an injured person will get are their super.
That's right, Tony. Particularly, as Nun said, when it's outside the scheme, the schemes of
Outside of
other
work.
insurance company schemes such as TAC or work cover. If it happens at home or while on holidays, then it's so important to have coverage that not just for your income or day-to-day income, but that lump sum benefit that will assist you to pay off, your house or anything else that sort of maintain your lifestyle, which you work so hard for on a day-to-day basis.
And as the whole thing evolves, all of a sudden we're finding that people are more aware of these benefits and lawyers are more prepared to pursue them, and it's a $1 trillion industry, believe it or not.
Well, look, I think out of all the areas of personal injury law, Tony's probably the one with the most growth, you would say, because it's still underutilised.
Got massive growth.
And, we had a client actually yesterday that, the client said to Sarah and I that they weren't aware they had any entitlements under the policy, and if it wasn't for Sarah looking into it, there was $100,000 in their pocket. So, it still staggers me how underutilised it is.
Well, in fact, viewers, when you go to a lawyer to see him for a car accident, work accident or public liability, you should always take with you your superannuation members' statements, because you don't know at that early stage what advice you can get to sort of set you on a path in case you don't make the recovery that you'd like to make.
Yeah,
correct?
And I think people think, superannuation, that it's got a message that it's 65, it's when you're older, it's when you retire, but that's not the case.
No.
It actually can be as prevalent to a 21-year-old to a 65-year-old, and that's a message I think is not publicised just enough yet.
I think also people just assume that they've got insurance cover with their superannuation fund, so everyone should definitely double check their policy, their member statement, to ensure that it's on there, and if it's not, make some inquiries as to how they go about actually obtaining that insurance, whether it be through the super fund or through a retail provider, such as a bank.
And I also recall that when I first started in the law many years ago, it's very hard to get a total and permanent disability benefit if you weren't at a particular age. But now, because of the evolution of this area of practice, people are getting paid out in their 30s, even
That's right.
younger,
Yes.
in some instances. Anyway, on that note, let's get on with this case law.
Yeah.
And we'll just add to it. Banovic and United Super Proprietary Limited. What are the facts of this case, Nuts?
So Milko Banovic was working as a formwork labourer back in 2006 and came from, migrated from Croatia with his family around 2001, 2002. Had an accident at work where, stripping some formwork, he fell down and I think dropped about a metre or two and suffered injury to his wrist. Over the course of time, looked back and forth to work, but had 3 surgeries, and ultimately made a claim with his fund to say that he's TPD or total permanent disabled, and that's really the meat of this case, and he ultimately had to issue in the Supreme Court of New South Wales to prove his case.
So the fund manager knocked back the claim, and the insurer that was behind the claim knocked it back as well?
That's right, Tony. They decided that based on some retraining that he undertook after his injury, after he'd ceased work, and some medical material that suggested that he might have a theoretical capacity for employment, given his education and age and his ability to retrain, that he therefore wasn't TPD. The court didn't agree with the decision of the insurer and the trustee, and actually said that because that they found that the decision was unreasonable on the basis that, firstly, the retraining occurred after the injury, he sustained the injury and ceased work, and secondly, based on a number of things, including his limited English, because he had relocated to Australia, his age, so at the time of the claim he was 48, but at the time of the decision he's 53, and given what would reasonably be available to him, given those circumstances, his education, his age and his disability, that he was unlikely to return to work.
Well, what's of interest is that it started off with a wrist injury.
Yep.
But viewers, this is one area of law where you can introduce other body parts that, strictly speaking, don't form part of the original injury. In his case, he started complaining of things like neck pain, left shoulder, interscapular region, thoracic spine, when bending and twisting.
Psychological symptoms.
Psychological. Also, what he's done is he's included things like blood pressure, cholesterol, diabetes.
All the medication he's taking.
So, viewers, this is one area where, strictly speaking, you don't have to rely on the injuries sustained at work. You can throw everything in there. You put it into the melting pot and it just helps.
Well, that's the message, to make sure if you've got any symptoms arising out of those, of your injury, even if it arises a little bit later, you've got to tell your doctors because, if you can prove that it's all stemming from that, then it does help. True, Sarah?
Absolutely. And the other case law actually indicates that where there's a contribution of or a collection of different injuries or illnesses as a result of the one incident, that the fund and insurer have to consider the consequences of the combined effect of those injuries,
yes.
Not just focus on, say, the physical injury and exclude the psychiatric. It has to be the combined effect of both.
But he's also taken a cocktail of drugs, Stilnox, Zoloft, Panadol, osteodiazepam, Voltaren and Panadine Forte. How can he possibly work with all these medications?
Yeah, look, I think, it sounds like the medical evidence was quite consistent to the fact that he was, can't go back to his old employment. But the thing that staggered me with this case is that they thought he was capable of, retraining and doing something different. But he only, I think, went to Form 8 in Croatia. I think at best he worked as a store handyman in Croatia and then basically might go to Australia with limited English and couldn't even complete any English courses to a high level. I just found this decision strange that they would push it to a point where it'd go to trial.
And it was $100,000, so you could imagine the legal costs.
That's right, Tony. And they also, in this case, the court awarded interest of $27,000 on the basis of the decision being so unreasonable that they take that from the date when it was unreasonable for the insurer or trustee to have made that decision.
Yep.
I thought also what was interesting about this case was that the court attacked the letter of decline in the claim, saying that they just sort of cherry-picked the parts of the medical reports they wanted to rely on without giving a constructive whole analysis or opinion of the particular doctors they were relying on.
That's a good point, Sarah. The courts look at the reasonableness of the decision, taking the totality of all the evidence.
That's right.
Viewers, we've got to go to a sponsors break. Stay tuned, we've got a couple more interesting decisions for you. Viewers, welcome back to the show. As we were talking about the last decision, this is such a complex area of law, that is superannuation and insurance law, that you really need to get legal advice. Nunz, you've got to get retraining more often than not. You've got to look at the issue of age, education, experience. Now, you can't possibly do that. There's so many twists and turns in these cases.
Yep.
You're very senior in what you do. What do you recommend to the viewers?
Oh, look, like I was saying before, Tony, you've got to seek legal advice because it's not only got an insurance feel to it, it's got a contractual feel. It's one of the more complex areas of litigation. And the most important part is a lot of clients don't know their rights. So, and that's what we do. And we can advise you on that and the merits of going forward. And it's integral.
And Sarah, Nunz just raised the issue. It's a combination of injuries, contract, trust law.
That's right.
Very complicated, isn't it?
It is really complicated, Tony. And it's not just about the insurer and trustee making a decision. The way they go about making a decision, it's the whole process.
The
and
stages
as I
they
explained
take.
to members, when they first lodge a claim, it's not as easy as lodging you write off your car, you lodge a claim, they pay out the benefit. It's very difficult. And because it is based purely on common law more than any litigation requirements such as work cover or TAC, it is all based on previous court decisions.
And the courts have to look at the construction of a trust because a lot of the decisions are based on trust law.
Exactly right. And that's what, look, I've got a little concern when a lot of financial advisors run these TPD claims. And look,
they're doing more and more often.
They're doing more often. And I get a little bit worried that they're not aware exactly the implications going forward because if it is something that gets litigated, they're not trained in that. We are, and as lawyers. So I really hope that even the financial advisors listen to this message because it's not as easy as just submitting a claim with some medicals, $100,000 in your pocket. It doesn't work that way.
If they misapply the law, then it's making it easier for the plaintiff because they not only sue the fund and the insurer, but they can sue the financial planner for giving advice.
That's right, Tony. We always wonder in those cases, and in particular the financial advisors that are associated with the particular insurer that's being pursued.
Yes.
Any
They join
financial
them as a
advice.
defendant.
That's right. They can be joined if the advice they've given is incorrect.
Because the issue is whether the person's relying on your advice.
That's right.
That's what the issue is. All right, on that note, let's get on to this case of Birdsall, Motor Trades Association of Australia. Another New South Wales decision, but it's irrelevant because it applies right across the country.
That's right.
2014 decision. What are the facts of this one, Sarah?
So, Tony, in this case, Mr. Birdsall was a 28-year-old motor mechanic who also injured his right wrist when lifting a really heavy gearbox in the course of his employment. He subsequently returned to work and kept working for a few weeks and then re-aggravated the wrist at work. He had some time off work and then returned doing part-time light administrative tasks for over a year.
And Nunz, what did the fund do?
So the fund ultimately knocked back the claim, and he issued proceedings in the New South Wales Supreme Court in which the court found in favour of the fund and said that he wasn't TPD according to the policy. So unfortunately, he didn't get his insurance component.
What were the main reasons why he failed, Sarah?
So there was a few issues in this case, Tony. The first one was his age, I think. The fact that he was 28 years old, yes, he had only done the motor mechanic work, but he had shown a capacity to do that administrative type work for more than a year before he was terminated from not being able to go back to his motor mechanic duties. The other thing the court determined was that it wasn't unreasonable for him to undertake some retraining to be able to go back to work, given the age involved.
The judge placed a lot of emphasis on the fact that if he had got retraining, in all probability, with little effort involved, he would have been able to undertake alternative employment.
That's right. And the other difference in this case compared to the case of Banafik we previously discussed is that the doctors also indicated that he had a capacity to go back to that type of work. And that's really important. If the doctors are saying that, you know, they've got the physical capacity to do it, he's got the intellectual capacity to do it, then the insurer and trustee can take that into consideration.
And that's why history is important. Not only obviously your age, your background, where you come from, migration, family, schooling, and that's why it's important that all those facts are obtained. And in this case, it being 28, the court found that he could do other jobs like I think it was customer service assistant, sales assistant, and a sales rep. Which, look, at 28, arguably, it's not like he's quadriplegic or a paraplegic. He's it's a wrist injury, so there was some merit in that argument, which ultimately the court accepted. And
sadly, the courts don't place any weight on the fact that you probably dislike doing anything but motor mechanic.
No, they don't. They actually have to look at the capacity, and the test is unlikely ever to return to work. So that allows the insurer and the trustee to look well into the future, not just in the next 1 or 2 years. The other thing that was really interesting in this case was that he had evidence that he had applied for 50 or 60 positions post-injury, which he'd been unsuccessful for. And the court held that wasn't enough to actually prove that he was TPD, that the actual availability for this particular member wasn't really relevant, whereas in the previous case, the court actually held that was relevant in the consideration of the claim. How does that work though? If he's applying for 50 or 60 jobs, Sarah, technically isn't he saying he's got a capacity to work?
No, he's trying to...
I'm just being devil's advocate here. How would you view that? Well,
technically, I think that is how the insurer views it. They definitely view it as that. Well, if you're applying for jobs, you obviously consider yourself to have capacity for work. You don't consider yourself to be totally and permanently disabled. But I think in this instance, because he was applying for jobs that were outside the realm of his previous education training experience, they were lighter work jobs that... Look, the argument was there to be made, but obviously the court didn't agree with it.
This was a standard definition that talks about unlikely to ever go back to work and exploring what your capacities are with age, education, experience. But there's been some definitions that are a lot worse than that, where they say unlikely to ever return to work again. They're very tough definitions, aren't they?
So more recently, the definitions the insurers have been using is the unlikely ever, as opposed to the unable ever, which is such a strict definition and really difficult to ever sort of prove. The other thing they're now adding to some of the definitions is that you have to first undergo retraining, or if you can undergo retraining to return to work, then you won't be TPD, whereas that's not usually part of a standard TPD definition.
Time's flying, and I really quickly want to go through this decision of Hanover Life re Australasia versus Wright. It's a federal court decision. Nunz, just briefly, what are the facts? Well, effectively,
Miss Paula Wright wanted some extra cover under her policy, and she requested 10 extra units, which was more coverage, and all she was given was 5 extra units, but the main issue was that she was excluded from any claim regarding her spine because on 2 or 3 occasions she saw basically an osteo who for her back, and they said, well, any time you get injured by reason of your spine, you're out. And that was really that was the crux of this claim.
And Sarah, in short, what did the federal court find? Because it went from the tribunal, Superannuation Complaints Tribunal, to the federal court.
The SCT, or the Superannuation Complaints Tribunal, reworded the definition, the underwriting definition, saying that a soft tissue, back muscle spasm isn't the same as if you suffer from an actual spinal injury, and therefore to exclude her completely, her back completely, was unreasonable.
Yep.
The federal court held that because it was a contractual nature between the insurer and the trustee, and it was underwritten by terms of a contract, that the SCT was outside their jurisdiction in terms of rewriting the
In effect,
clause.
what she should have done is gone to another insurer to get someone that was prepared to underwrite her claim. Correct?
Yes.
Because if one fund's not prepared to do it, others might.
Well, that's right. Or they might just put the exclusion to a specific part relating to that particular part of the back, as opposed to the whole spine, which is what she had here.
Nunz, Sarah, we've come to the end of the show. Thanks for coming on board.
Thanks.
Viewers, thanks for watching. Go to our previous episodes on YouTube. Go to Facebook and Twitter. Stay tuned for future episodes, and always remember to stay safe.